And in today's tutorial, it's going to be a continuation of the course POL211, and we're going to be taking our bearing today from the English law. With this being said, let's hop straight into it. Okay, I believe we can the board is it's clear enough, and we can actually see what we have. It's raining, and most time, all right, whenever it's raining now, I might not be able to use your intro set. So I just hope we can actually see the board clearly. I have POL211. And we're starting from the English, from the English law. Okay. Now, the English law, which comprises of acts, all right, it comprises of acts and ordinances. Just a moment. All right, it comprises of acts or orders in the council that are applicable directly to Nigerian as the statutes of general application. Okay, comprises, all right, acts, okay, or others, or others, okay, or others in council, others in council, others in council, okay, that are applicable directly to Nigerian as a statute of general application. Now, the received English law is part of our colonial legacy, right? That is very much correct, as the English law has a lot to do with our colonial legacy. Okay, so order in council that are applicable, that are applicable directly, all right, applicable directly to Nigeria, okay, as a statute of general application to Nigeria as a statute of general application. Okay, now, following the Berlin Conference of 1884 to 1885, Berlin Conference of 1884 to 1885, which was summoned by the Chancellor of Germany, Otto von, all right, Britain was empowered to control the coasts from Lagos up to Calabar. All right, this conference gave gave Britain the empowerment. All right, following this conference, Britain gave the empowerment to control the coast from Lagos up to Calabar. All right, gave Britain the empowerment to control the coast, all right, from Lagos up to Calabar. These laws are referred to as, okay, now, laws that came into existence, even, all right, law that came into existence at the time Nigeria was not even contemplated, all right, as a country. This law are referred to the statutes of general application. Okay, now we said something about general application here. So now, speaking of the statutes of general application, statutes of general application. Okay, law, they are laws that came into existence at the time, laws that came into existence at the time. Okay, laws that came into existence at the time Nigeria was not even in contemplation. All right, Nigeria was not in contemplation. All right, then Nigeria was seen, all right, ruled as colony and protectorate. All right, so these statutes of general applications are the law that basically was used in ruling Nigeria then as a colony and protectorate, even before and even after Nigeria was created. All right, this law still existed to some extent. All right, so we have sources of Nigerian legal system. Okay, English law happens to be one of the sources of Nigerian legal system. But now let's talk about some other sources of Nigerian legal system. Okay, so we have the likes of customary law. Okay, we have the likes of customary law. This law must undergo 3 validity tests. All right, customary law undergoes 3 validity tests. One is, okay, just a moment, undergoes 3 validity tests. Okay, now we have it. The law, customary law, is not against the word repugnant is used. It is not repugnant to natural justice, equity, and good, all right, conscience. All right, the following cases are applicable in the case of Edet versus ASEAN in 1932. All right, Edet versus ASEAN in 1932. We have the Re Effiong Atta in 1930, and we have the Mariana versus Sadiku Ejo in 1961. All right, now the customary law happens to be one of the sources of Nigerian legal system. Also, we have the international law. All right, the international law binds respective states and regulates their mutual coexistence. All right, international law. So we also have international law. All right, it binds, okay, binds respective states and regulates their mutual, okay, coexistence and relationship. Okay, now the sources of international law include international customary practices, all right, treaties, bilateral agreements, and conventions. Those are the sources of international law. And the bottom line here is that international law is this kind of law that binds respective states and regulates their mutual coexistence and relationships. Okay, so we have that as that. Now, laws made by the legislature, all right, is called statutes, or are called statutes. Laws made by the legislature are called statutes. All right, that's statutes. All right, statutes. That's it. Okay, so laws made by the legislative are called statutes. Legislation may be primary or subsidiary legislation. All right, legislation may be primary or Okay, let's just put it here. Legislation, all right, may be primary or, okay, maybe primary or subsidiary slash subsidiary. Okay, so we have that as that. Now, statutes are laws that enact from major legislative arm of government, like what you just said, that the laws made by the legislative arm of government, all right, is what we refer to as statutes. Okay, they are laws made by the legislative arm of government. Okay, now there's also something called delegated legislation or subsidiary legislation. Okay, delegated slash subsidiary leg. When we say delegated legislation or subsidiary legislation, what are we talking about? A subsidiary on now. This is kind of legislation made by a person or body other than the sovereign parliament. When we say delegated, all right, it's like the passing on of power, all right, delegated, the passing on of power to a, all right, less, let me not use the word less substantial, let's just say delegation of power or passing on of power to your subordinate, all right, and usually temporal. Okay, pass or you appoint someone who is not in the same position as you are, all right, probably in the same position depending on how the case may be, but the point is that the authority himself passed on his responsibility for a period of time to another. Okay, so that it says here that it is made, this kind of legislation is made by a person or a body other than the sovereign parliament. All right, made by a body slash person other than, okay, the sovereign parliament. Other than the, I think it's parliament, sovereign parliament. Okay, so we have that as that. Now, I'm thinking that's that on the delegated legislation. Now, we have the customary law, okay, one of the source of Nigerian legal system as well. Nigeria became truly federal state on October 1st, 1959, a federal state. Okay, Nigeria became truly a federal state, all right, in now, I think we are live again. That was a thing from the network. Okay, so Nigeria became a federal state truly in federal state on first, all right, on October 1st, October 1st, 1959. Okay, although I did my research, it was basically showing 1954. All right, so basically 59, 54 is still in 50. All right, so it is still considerable. Now, customary law is the law of conduct accepted by members of the community as binding among them. All right, customary law is the law of conduct. Okay, the law of conduct that is accepted by members of the community as a or as binding customary law. All right, accepted. This is the law that is accepted by members of the community as binding among them. All right. Now, Nigerian customary law can be classified into what we call ethnic, all right, customary law, and Muslim law. Muslim law, which is Islamic law. Now, the ethnic customary law is indigenous, is unwritten, and diverse from one ethnic group to the other. All right, let me take that again. The ethnic law, the ethnic customary law, okay, is diverse, unwritten. All right, it is unwritten, it is indigenous. That is the ethnic customary law, right? And it varies from one ethnic group to the other. While the Muslim law, however, largely written in the Quran and practice of the prophets. Okay, so we have that as that. So permit me to raise the board so we can take the case law. Miss Regina, you came a bit late today. Are you even on the stream? Okay. Very well. Maybe it's the network. Maybe she's at work or something. So I know she doesn't come late usually. She's actually the one waiting for the class. Does wait for the class, I mean. Now we have the case law. Now what we need to understand here is that judicial precedent is one of the main source of Nigerian law. Is one of the main source of Nigerian law. Now, when we say judicial precedent, what are we talking about? Okay, now it is a judgment or decision of a court cited as an authority for the purpose of persuading the court to decide a particular or a similar case on the same principle as the previous one. Okay, now the bottom line here is that judicial precedent, all right, is the judgment or decision of a court, all right, the judgment or decision of a court. Okay, now excuse me, this decision, all right, of a court cited as an authority. This decision is being cited as an authority. Okay, cited as an authority for the purpose of deciding, all right, a similar case on the same principle, all right, as the previous one. Now, what are we saying in essence? This court of authority has decided over a case. Okay, so now other courts, okay, other courts, based on the decision of this court of higher authority, okay, are now implementing this same, all right, this same decision taken in this higher court of authority, all right, to judge a similar case based on the principle of the previous one. Are we together? So it says here that cited as an authority for the purpose of persuading the court to decide a similar case on the same principle as the previous one. All right, to decide a case based on a similar previous one. Okay, now let's take note of this abbreviation. We have the UNO, the AU, the ILO. Okay, these are treaties and resolutional bodies. All right, treaties and resolutional bodies. Okay, treaties and resolutional bodies. We have UNO, AU, UNO, we have AU. The UNOC is an acronym for Nations, United Nations Organization, that's UNO. We also have the AU, which is the African Union. Okay, we have the ILO, which is the International Labor Organization. Okay, International Labor Organization as International Labor Organization. So these are the three treaties and resolutional bodies. Okay, now let's continue. Money bill. Now, before we talk about this, you need to understand that human beings by nature are dynamic. Therefore, law must be right and is very dynamic. Law must be dynamic as human beings are dynamic. Human beings are not static in nature. They are dynamic. So laws must also be dynamic. Okay, are we together? Awesome. Now, a money bill, speaking of which, a money bill. Okay, when we say money bill, what are we talking about? Money bill. Now, it says here that an appropriation bill is also seen as a money bill or supplementary appropriation bill, which include any other bill for payment, right, issue or withdrawal from what we call consolidated revenue fund. All right, so we have, I think we have two definitions here. All right, it's money bill is also seen as an appropriation bill, all right, that is used for payments, issue or withdrawals. All right, an appropriational all right, appropriational bill used for payment, all right, issue, all right, or withdrawals, all right, or withdrawal okay, for the consolidated revenue fund or any other public fund or the Federation of Nigeria. All right, withdrawal for what we call, okay, withdrawal, are we together? Withdrawal from consolidated revenue fund withdrawal from Consolidated Revenue Fund, CRF. All right, the withdrawal made from Consolidated Revenue Fund or any other public fund of the Federation of Nigeria. All right, or any other public fund. All right, as well. Any other public fund of the Federation of Nigeria. Federation of Nigeria. Okay, so we have now we also have what is called ordinary bill. Ordinary bill. Now, ordinary bill, an act of National Assembly commences a bill and may be introduced, all right, in the Senate. All right, an act in the National Assembly commences, all right, as a bill and may be introduced in the Senate or House of Representatives. Okay, now this is kind of the bill that starts as an act. Okay, starts as an act in the National Assembly. Okay, so we have, okay, then commences as a bill, and this bill may be introduced in the Senate or House of Representatives. Which may be introduced in the Senate or House of Representatives. Okay, now all bill, all right, now we have, just a moment. Now, money bill or the private bill, the ordinary bill, whether money bill or the ordinary bill, goes through the same process of any ordinary bill. All right, whether money bill or ordinary bill, the bill whatsoever goes through the process of any ordinary bill. Okay, so we have that as that. So let's talk about the types of legislation very quickly before we call it a wrap for today, and take our bearing from international interpretation of statutes in our next class. So now, speaking of the types, all right, speaking of the types of okay, just a moment. Speaking of the types of legislation, we have the Public General Act. Okay, types of legislation, we have the Public General Act. Types of leg, we have Public General Act. Okay, this applies to everyone and everywhere within a state. That is the Public General Act. We have the Local Act, which applies to a particular locality. All right, local act applies to a particular locality. And we have the consolidating act. All right, this is a law statute passed which will enact the context of earlier statutes. All right, with such modification and addition as necessary to produce a coherent whole. That's a consolidating act, like the name says, consolidate. All right, to buttress what has been. Also, we have a code. All right, a code is also a statute which attempts to put together one document the provision of an existing legislation. All right, a code, just like the consolidation too. Consolidation. So we have three, we have four. So I think on this note we'll call it a wrap for today. But just before then, when we say rule of law, what do we mean by rule of law? What do we understand by the term rule of law? Okay, now rule of law is a constitutional doctrine which emphasizes the supremacy of the law. All right, it emphasizes the supremacy of the law as administered by the law courts. All right, so literally the rule of law means governance of law. Okay, so on this note we'll call it a wrap for today. In our next class we'll take it off from the interpretation of statutes. So thank you very much, everyone. I believe we've been able to gain a thing or two into this class. Please let us do all to keep our notes up to date, submit appropriate quarters. Thank you very much, and look forward to seeing all the subsequent tutorials. Do have a wonderful evening. Good night.